Okay, welcome and thank you for joining today. The topic of our webinar today is Hot Topics in Prospectus Filings and Exemptions, what small and medium issuers need to know. My name is Maria Lobsher. I'm a senior accountant in the corporate finance branch of the OSC, and I'm the coordinator for the SME Institute this season. I'm delighted to introduce our speakers for today's session. Joanna Akawi is senior legal counsel, Luke Biancourt is legal counsel, and Julie Ferris is an accountant, all in our corporate finance branch. And just some housekeeping items before we begin. You can submit questions throughout the presentation using the chat feature, and we will be answering them at the end of the webinar. If for any reason we cannot get to your question, we'll reach out to you after. We'll also be sending an evaluation after this session, and we'd appreciate your feedback. And lastly, at the end of the session, you will be able to screenshot proof of attendance for possible CPD requirements. So just look out for that. And so before we begin, I'd just like to remind participants that the views expressed in this presentation are the views of corporate finance staff and do not necessarily represent the views of the Commission. As such, anytime the term "we" is used during the presentation, this refers to OSC corporate finance staff's views, and again, not necessarily the views of the Commission. The presentation is provided for general information purposes only and does not constitute legal, accounting, or technical advice. Information has been summarized and paraphrased for presentation purposes, and the examples have been provided for illustration purposes only. Responsibility for making sufficient and appropriate disclosure and complying with applicable securities laws remains with the company. Information in this presentation reflects securities laws and other relevant standards that are in effect as of the date of the presentation. The contents of this presentation should not be modified without the express written permission of the presenters. And lastly, this document should not be distributed externally. The objective of the OSC SME Institute is to support small and medium-sized businesses in facilitating cost-effective compliance through issuer outreach and education. It is important for issuers to know securities regulatory requirements, and we are here to help them navigate regulatory waters. The idea is that if we can help issuers to better understand the disclosure requirements, they can focus their resources on building their company. Ultimately, we have the same goal, for issuers to provide appropriate and meaningful information to investors and stay onside regulatory requirements. It is important to remember that at the end of the day, investor confidence in the information that companies provide is critical to the success of the company. And so for today's SME webinar, we're going to focus on, first, a general overview of the prospectus regime, including types of prospectuses and offerings, the filing and review process, and new developments. Next, we'll provide an overview of some recent prospectus exemptions. And lastly, we'll review some hot topics, including the use of proceeds disclosure and sufficiency of proceeds and financial condition concerns. I will now pass it on to Luke, who will take us through a general overview of the prospectus regime.
Thanks, Maria. We'll start today by covering the different types of prospectuses and offerings. A good starting point is that any issuer that wants to raise capital by issuing securities has to do so either under a prospectus or under an exemption from the prospectus requirement. I'll focus on prospectuses, and Joanna will speak to certain prospectus exemptions later on. Also, sometimes we get asked what is a security, and that can be very open-ended. So for purposes of this session, we are assuming that a determination has already been made that an issuer is issuing securities. A prospectus is a detailed disclosure document that must provide full, true, and plain disclosure of all material facts relating to the securities issued or proposed to be distributed. The content requirements of the prospectus are prescribed under securities laws, notably under what we call forms. For example, Form 41-101-F1 spells out what information is required in a long-form prospectus. As a result, the prospectus provides investors with specific and detailed disclosures about the entity, its business, its principals, directors, and officers, and the securities being offered under the prospectus. The requirement to provide full, true, and plain disclosure is a very important requirement, which is also evidenced by the fact that issuers, as well as underwriters and certain other persons, depending on circumstances, are required to certify to this standard in the prospectus itself. And that leads to liability, because where a prospectus contains a misrepresentation, a purchaser who purchases a security offered by the prospectus during its distribution has a statutory right of action for damages against the issuer, its directors, and the underwriters that sign certificates, among others. There are various types of prospectuses that an issuer can use to sell their securities depending on their needs, stage of development, and even their own preferences. I will go briefly over them. Firstly, a long-form prospectus is generally used by an entity going public for the first time under an initial public offering or IPO, or by an entity that is not eligible to use a short-form prospectus, which I will speak to shortly. In the former category, after an entity receives a receipt for its final prospectus under an IPO, it becomes a reporting issuer, which means that going forward, it is subject to continuous disclosure obligations, such as filing annual and interim financial statements. These requirements are predominantly spelled out in National Instrument 51-102 Continuous Disclosure Obligations and its related forms. A short-form prospectus is a prospectus that allows existing reporting issuers to incorporate certain continuous disclosure documents that have already been publicly filed into the short-form prospectus, as opposed to disclosing that information directly into the prospectus itself. These documents incorporated by reference include financial statements and management discussion and analysis, annual information form, management information circular, material change reports, and business acquisition reports. And as may already be evident, by enabling these documents to be incorporated by reference into the prospectus, it provides a more streamlined method by which issuers using a short-form prospectus can access Canadian capital markets. In addition, staff's timing to review and issue initial comments for a short-form prospectus is generally shorter than for a long-form prospectus. But as previously noted, short-form prospectuses can only be used by issuers that are already reporting issuers. In other words, entities that are going public under an IPO are unable to use a short form. In addition to this, issuers also have to meet a number of eligibility requirements in order to be able to file a short form prospectus. The more common requirements include having equity securities listed on a qualified exchange, as well as having current annual financial statements and annual information form, among other things. This is noteworthy as issuers that are venture issuers are not required to file a current annual information form and as such might not be able to utilize a short form prospectus if they want to raise capital. Other types of prospectuses include a shelf prospectus and post-receipt pricing prospectus or PREP prospectus. A base shelf prospectus is a form of short form prospectus used by an issuer that allows a reporting issuer to qualify and distribute certain securities over a 25-month period up to the indicated aggregate dollar value of securities shown in the final base shelf prospectus. A single base shelf prospectus can include multiple types of securities, including, for example, common shares, units, warrants, subscription receipts, and debt securities. And it allows an issuer to access the capital markets quickly because it can draw down from the aggregate amount indicated in the base shelf prospectus by filing a prospectus supplement that includes the details of a particular offering and that is filed and delivered when the actual distribution of securities occurs. A post-receipt pricing prospectus or PREP prospectus allows a reporting issuer to obtain a receipt for a final prospectus without pricing details. A supplemented PREP is then filed containing the pricing information. This type of prospectus is usually used by reporting issuers doing cross-border financing since it allows Canadian dealers to coordinate with timing with US dealers. A PREP prospectus can be based on a long-form or short-form prospectus. I will now briefly go over some of the more common forms of offerings that can be carried out using a prospectus, being the bought deal, the overnight marketed offering, and the best efforts offering. A bought deal is an offering where the underwriters have agreed to purchase all the securities of an issuer that are being distributed under the prospectus and then resell those securities to investors. Because the securities are already committed to be purchased by the underwriters, the financing risk to issuers, or in other words, the risk that the issuer cannot raise the capital it is seeking, is much lower. However, because there's risk as passed to the underwriters, the issuer generally sells the securities at a lower price to the underwriters than it would under a different form of offering. In a marketed offering, the underwriters agree to purchase the securities from the issuer but have not agreed to a specific price or amount. Rather, the underwriters would first market the securities to potential investors and then determine the specific details of the offering afterwards. An overnight marketed offering is a marketed offering with the marketing occurring over a brief period, i.e. overnight, with the pricing being finalized the next morning. The financing risk to issuers is greater than a bought deal, however, the price for the securities is usually higher as well. In a best efforts offering, the underwriters use their best efforts to market the securities to investors, but are not liable to purchase the securities for their own account in the event purchasers are not found. Under a best effort offering, the risk that the issuer cannot raise the capital it is seeking is all on the issuer. I will now move on to discuss the prospectus filing and review process. This slide gives an overview of what can be expected when filing a prospectus with the Ontario Securities Commission. The process generally starts with determining which of the provincial securities regulators is the principal regulator of the issuer that is filing the prospectus, as this is the body with whom that entity would primarily be dealing with. And assuming the issuer successfully gets through this filing and review process, the process ends with a final receipt for the prospectus, which the issuer can then use to sell its securities. We will go over these steps in more details in the following slides. As you're aware, securities legislation in Canada is a matter of provincial jurisdiction. So as a first step in any prospectus filing, an issuer needs to determine its principal regulator. You can refer to National Policy 11-202, Process for Prospectus Reviews in Multiple Jurisdictions for more guidance on how to determine the principal regulator. Generally, the location of an issuer's head office will be determinative if the head office is in one of the specified jurisdictions listed on this slide. However, in a situation where an issuer's head office is not located in a specified jurisdiction, the other listed factors will be relevant in determining with which of the specified jurisdictions the issuer has the most relevant significant connection. In the event that the prospectus raises a novel aspect or significant or unique matter that an issuer feels should be discussed with the regulator before a preliminary prospectus is filed, we generally encourage issuers to pre-file with us so that these issues can be addressed. Prospectuses filed on a confidential pre-filed basis are subject to a full review, meaning the same timing for review that is applied to a long-form prospectus, even if the pre-filed prospectus is a short form. It is also important to keep in mind that the length of time required depends on the complexity and the novelty of the issues. We do consult with other CSA jurisdictions on novel issues, which is another reason why any novel aspect should be pre-filed. And in the event that relief from certain requirements is granted, a description of the relief is generally disclosed in the prospectus. Issuers must carefully consider whether a draft preliminary prospectus is at an appropriate stage for a confidential pre-file review. If we determine that a draft is not at an appropriate stage, we may ask the submission be withdrawn. This may occur if the prospectus does not meet the expectations set out on the slide. These include, for example, that the draft prospectus must contain all financial and non-financial disclosure that would be in the actual prospectus filing. In addition, the OSC will not generally review pre-files of non-offering prospectuses with certain exceptions, or prospectuses that solely qualify the issuance of securities on conversion of convertible securities, such as special warrants. The next step in the process is to file the preliminary prospectus. It is important to properly file all of the applicable documents. They include, but are not limited to, the documents listed on the slide. For example, in addition to the preliminary prospectus itself, the issuer must file the qualification certificate for a short-form prospectus, the personal information forms for each director and executive officer of the issuer, and the auditor's comfort letter regarding audited financial statements. Failure to file the required documents may delay the preliminary receipt. From the date of the preliminary long-form prospectus receives a receipt from the director, generally upon filing, staff have 10 business days to conduct a full review and issue initial comments. A short form generally entails a shorter review period, as staff have 3 business days to issue initial comments in the context of a short form prospectus. So how long does it take from beginning to end? Well, that depends. There are a variety of factors that affect the prospectus review process, but here are some tips to responding to staff's comments that could lead to a faster resolution of any issues identified over the course of our review. Firstly, make sure the responses comprehensively address staff's comments. Where answers aren't clear or fail to address staff's concerns, you can expect further comments from staff seeking more information to your response. Second, cite authoritative references where appropriate, especially when responding to technical accounting comment. This aids staff in understanding the basis of your responses and interpretive reasoning. And lastly, provide proposed disclosure to be included in the prospectus to address staff's comments where appropriate. For example, where a response to a staff comment enhances or provides further clarity on certain disclosure in a prospectus, it likely would be beneficial to investors to have that information as well. And how those identified issues are resolved can also vary. Some examples of the possible outcomes from our review are listed on the slide. They include, but are not limited to, material disclosure changes to the prospectus itself, the correction and refiling of significantly deficient continuous disclosure filings that an issuer incorporates by reference into a short-form prospectus, or a change in the structure of the offering, which we will discuss a bit later in the presentation. So what do we look for when we review a preliminary prospectus? A number of things, including the quality of the prospectus disclosure, as well as the offering structure and size. This slide gives an overview of the key focus areas which staff provide comments on when conducting a prospectus review. Section 61 of the Securities Act sets out grounds for the director to refuse to issue a receipt for a prospectus, including for substantial non-compliance with securities law requirements, or if the aggregate proceeds from the offering and other resources of the issuer are insufficient to achieve the purpose of the offering. Julie will discuss the latter in more detail later in the presentation. After staff's review is complete, and assuming all issues have been resolved, staff will generally recommend that the director of the corporate finance branch issue a receipt for the final prospectus and the issuer is cleared to file final materials. Similar to preliminary prospectus filings, it is important to properly file all of the applicable documents. They include, but are not limited to, the documents listed on the slide. For example, in addition to the final prospectus itself, the issuer must file any undertakings, submission to jurisdictions form, and express consents. Other considerations for filing a final prospectus include the time between the date of the preliminary prospectus and the date of the filing the final prospectus. There is generally a 90-day deadline. It is important to keep in mind that if a material change occurs after the filing of the final prospectus but before the completion of the distribution under the final prospectus, then an amendment to the final prospectus should be filed in order to incorporate the change. That concludes the general prospectus filing process. I'll pass it on now to Joanna now, who will take us through some new prospectus developments.
Thanks, Luke. The well-known seasoned issuer, or WICSI, regime is a streamlined base shelf prospectus filing system that is available to mature, well-established, and closely followed reporting issuers. It was implemented as a pilot project in January of 2022 by coordinated local blanket orders across Canada. And it allows qualifying WICSIs to file a final base shelf prospectus without first filing a preliminary prospectus, and to receive a prospectus receipt on an accelerated basis without staff's prior review of the prospectus. In addition, a WICSI base shelf prospectus can omit certain information, including the number of securities qualified for issuance under the prospectus. In other words, the issuer can file an unlimited shelf. The WICSI regime is not available for investment funds. To qualify as a WICSI, an issuer must have either outstanding listed equity securities that have a public float of at least $500 million, or at least $1 billion aggregate principal amount of non-convertible securities, other than equity securities, distributed under a prospectus in primary offerings for cash in the last 3 years. In addition, to use the WICSI regime, an issuer must have been a reporting issuer in at least one jurisdiction in Canada for at least the preceding 12 months and have no asset-backed securities. Even if it qualifies as a WICSI, an issuer may not use the WICSI regime if it is an ineligible issuer. For example, an issuer that has not filed all continuous disclosure documents that it is required to have filed would be an ineligible issuer and would not be permitted to use the WICSI regime. Similarly, an issuer that was during the past 3 years an issuer whose operations have ceased, or an issuer whose principal asset is cash, cash equivalents, or an exchange listing, and so excluding capital pool companies or CPCs and special acquisition corporations or SPACs, would be an ineligible issuer. An ineligible issuer could also be an issuer that was subject to any bankruptcy or insolvency proceedings, or a cease trade order in the past 3 years, or an issuer that was subject to any penalties or sanctions, or whose subsidiary was subject to any penalties or sanctions in the past 3 years. As I mentioned earlier, the WICSI regime was implemented via blanket orders. Amendments to National Instrument 44102, which is the instrument governing shelf distributions, are being considered to create a permanent WICSI system in Canada. Next, I will discuss 3 prospectus exemptions: the listed issuer financing exemption, the self-certified investor prospectus exemption, both of which took effect in 2022, and the offering memorandum prospectus exemption, which was recently amended. As Luke mentioned, Section 53 sub 1 of the Securities Act prohibits the distribution of a security without a prospectus. However, several prospectus exemptions allow issuers to distribute their securities to purchasers without a prospectus, provided that certain conditions are met. Prospectus exemptions are largely contained in National Instrument 45106, but can also be found in other instruments and rules. There are many types of prospectus exemptions, such as capital raising exemptions and transaction-based exemptions, and exemptions for certain types of investors, such as an issuer's directors, officers, consultants, and employees. Today, I will discuss 3 prospectus exemptions: the listed issuer financing exemption, the self-certified investor prospectus exemption, and the offering memorandum prospectus exemption. The listed issuer financing exemption is designed to facilitate retail investor participation and to provide private placement investors with more consistent disclosure for reporting issuers with complete, accurate, and up-to-date continuous disclosure records. The listed issuer financing exemption is available to reporting issuers that have securities listed on an exchange recognized by a securities regulatory authority in a jurisdiction of Canada. However, the exemption cannot be relied upon by special purpose acquisition companies, capital pool companies, growth acquisition companies, or any similar person or company. It is also not available to investment funds. The exemption is intended to allow an issuer to raise limited amounts of capital from any person based on the issuer's continuous disclosure filings. For this reason, the issuer must have been a reporting issuer in at least one jurisdiction of Canada for at least 12 months preceding the offering. In addition, the issuer must have filed all periodic and timely disclosure documents it is required to have filed. And the exemption cannot be used by an issuer whose operations have ceased, or an issuer whose principal asset is cash, cash equivalents, or its exchange listing. The exemption is not available to an issuer that intends to allocate its available funds to complete a significant acquisition, a restructuring transaction, or any other transaction for which it seeks security holder approval. And this restriction is to ensure that an issuer using the exemption has an operating business that is already described in the issuer's current disclosure. There is no requirement to have a minimum offering amount. However, if following completion of the offering, the issuer will not have sufficient available funds to meet its business objectives and liquidity requirements for a period of 12 months, the issuer must set a minimum offering amount so that following completion of the distribution, it will have sufficient funds to meet its business objectives and liquidity requirements for a period of 12 months. The amount raised under the exemption in a 12-month period must not exceed the greater of $5 million or 10% of the issuer's aggregate market capitalization to a maximum of $10 million. And distributions of securities made under the exemption during the 12-month period may not result in more than 50% equity shareholder dilution. The issuer is restricted to offering listed equity securities or units consisting of listed equity securities and warrants convertible into listed equity securities. The exemption cannot be used for the distribution of subscription receipts, special warrants, or convertible debentures. To use the exemption, an issuer must issue a news release announcing the offering, and before soliciting purchasers, the issuer must file both the news release and an offering document with the securities regulatory authority in each jurisdiction where the offering is being conducted. No solicitation of investors is permitted prior to the filing of the news release and offering document. The offering document must be prepared in the form prescribed by Form 45106 F19, and this uses a Q&A format, and it must be certified by the issuer's CEO and CFO. Together with the continuous disclosure documents, the offering document must disclose all material facts about the issuer and its securities and must not contain a misrepresentation. The distribution must end no later than the 45th day after the offering is announced, and a report of exempt distribution must be filed within 10 days of the distribution of the securities. Equity securities issued in reliance on the exemption will be freely tradable, but they will be subject to a seasoning period. This seasoning period will be satisfied by the issuer being required to be a reporting issuer in good standing for the prior 12-month period in order to rely on the exemption. So this differs from the accredited investor exemption, for example, where there is a 4-month hold period from the date of distribution. The issuer will have primary offering liability to purchasers of securities under the exemption, regarding misrepresentations contained in the offering document and its 12-month continuous disclosure record. Purchasers under the exemption will have a right of action for damages and a right to rescind the purchase within a certain time limit. The issuer and others will also be liable under the secondary market liability regime to any purchaser or seller in the secondary market in the event the offering document contains a misrepresentation. Next, I'll talk about the self-certified investor prospectus exemption, which was implemented in Ontario in October of 2022 as an 18-month pilot project. The exemption recognizes that certain individuals possess the necessary business knowledge through their education or experience to make an informed investment decision, but may not meet the financial thresholds or other criteria required to qualify as an accredited investor. Under the exemption, issuers may distribute securities to investors that certify that they meet qualifying criteria based on relevant education or experience. As mentioned, the qualifying criteria are based on an individual's education or experience. The qualifying criteria related to education are intended to capture retail investors whose education provides them with the ability to assess and understand the potential risks of investment. There are many options, but some examples are investors who have obtained certain designations, such as the Chartered Professional Accountant designation, investors who hold an MBA focused on finance, or an undergraduate degree in finance, or an undergraduate degree in business or commerce with a specialization in finance. It also includes investors who are admitted to the practice of law in a jurisdiction of Canada and dedicate at least 1/3 of their practice to providing legal advice in respect of distributions of securities or in respect of mergers and acquisition transactions. And it also includes investors who hold the Certified Financial Planner or Financial Advisor credential in good standing from a credentialing body approved by FSRA. The qualifying criteria related to business experience are intended to capture retail investors who have gained management, policymaking, engineering, product, or other relevant operational experience at a business that operates in the same industry or sector as the issuer, and are able to adequately assess and understand the risk of an investment in the issuer. The self-certified investor prospectus exemption is only available to non-investment fund issuers that have a head office in Ontario, and investors must be Ontario residents. The exemption allows for a self-certified investor to invest up to $30,000 under the exemption in each calendar year. The investor is required to certify that they meet the qualifying criteria and is also required to read and acknowledge a detailed risk acknowledgement form that explains some of the risks of investing without a prospectus. To facilitate tax planning, as self-certified investors, permitted designates may purchase securities. And if this happens, there would be a combined $30,000 purchase limit. As with each prospectus exemption that we are discussing today, issuers that rely on this exemption are required to file a report of exempt distribution within 10 days of the distribution. Next, I'll talk about the offering memorandum prospectus exemption. This exemption was originally designed as a small business financing tool to help early stage and small businesses raise capital from a large pool of investors without having to comply with the more costly prospectus regime. Under the offering memorandum exemption, issuers prepare and deliver to investors an offering memorandum, and that has to follow a prescribed form. The offering memorandum must disclose certain information about the issuer and include audited annual financial statements, but does not require the same level of disclosure as a prospectus. Investors are required to complete and sign a form highlighting the key risks associated with investing under the offering memorandum and to confirm their status, which I'll talk about more on the next slide, and that the investor is within investment limits, if applicable. It's important to note here that features of the offering memorandum exemption vary between jurisdictions in Canada, for example, with respect to purchase limits and the types of issuers that can make use of the exemption. And the information in this presentation pertains to the offering memorandum exemption in Ontario. In Ontario, the offering memorandum exemption is not available for issuers that are investment funds, and it's also not available for the distribution of a short-term securitized product. Under the exemption, investors may be subject to purchase limits depending on their financial circumstances. The exemption uses the concept of an eligible investor. So an eligible investor is a person or a company that meets certain criteria related to their net assets or their net income before taxes. So as an example, the following individuals would qualify as eligible investors. First, an individual with net assets in excess of $400,000 would be an eligible investor, and an individual with net income before taxes of at least $75,000 in each of the 2 most recent calendar years, and who reasonably expects to exceed that income in the current calendar year would also be an eligible investor. Purchase limits in Ontario vary. At the bottom end is $10,000 for a purchaser that is not an eligible investor, and that can go up to $100,000 for a purchaser that is an eligible investor and that receives advice from a portfolio manager, investment dealer, or exempt market dealer that the investment is suitable. And there are no purchase limits for purchasers that are accredited investors or who qualify under the Friends, Family, and Business Associates exemption. The offering memorandum must be in required form and contain audited annual financial statements. It must incorporate by reference marketing material if used, and it must contain a certificate signed by the issuer's CEO, CFO, and 2 directors, and any promoter. And the certificate must contain a statement that the offering memorandum does not contain a misrepresentation. Investors under the offering memorandum prospectus exemption have a 2-day withdrawal right, and they also have a right of action against the issuer for rescission or damages if the offering memorandum contains a misrepresentation. The offering memorandum and marketing materials must be filed with the regulator, but they will not be subject to prior review by the regulator. An issuer must, within 120 days after the end of its financial year, deliver audited annual financial statements to the regulator and also make those statements reasonably available to each purchaser under the offering memorandum exemption. An issuer that issues securities under the offering memorandum exemption is designated as a market participant and subject to certain record keeping and compliance obligations. An issuer must make reasonably available to each purchaser under the offering memorandum a notice of each of the following events: discontinuation, a change of industry, a change of control, and that notice must be provided within 10 days of the occurrence of the event. As I noted earlier, amendments to the offering memorandum exemption recently took effect. These amendments clarified the disclosure requirement for an offering memorandum. In addition to the prescribed content, an offering memorandum must also contain sufficient information to enable a reasonable purchaser to make an informed investment decision and must not contain a misrepresentation. The amendment set out new offering memorandum disclosure requirements, including particular requirements for issuers that are engaged in real estate activities and issuers that are collective investment vehicles. So, pursuant to the amendments, real estate issuers are required to provide an independent appraisal of an interest in a real property if the interest will be acquired from a related party, or if a value for that interest is disclosed in the offering memorandum. Also pursuant to the amendments, in Ontario, if more than 60 days have elapsed since the end of the second interim period, the offering memorandum must be amended to include interim financial report for this period, or an additional certificate must be appended to the offering memorandum. In the second case, this certificate must be dated after the end of the issuer's most recently completed second interim period, and it must certify that the offering memorandum does not contain a misrepresentation when read as of this new date, and that there has been no material change in relation to the issuer that has not been disclosed in the offering memorandum, and that the offering memorandum provides a reasonable investor with sufficient information with which to make an informed investment decision. The certificate must be signed by the issuer's CEO, CFO, 2 directors, and any promoter. The amendments also clarified that an offering memorandum must be amended if a material change occurs with respect to the issuer prior to closing of the offering. If a significant amount of proceeds of the offering will be invested in, loaned to, or otherwise transferred to another issuer that is not a subsidiary controlled by the issuer, the offering memorandum must include disclosure regarding that other issuer, including financial statements. And that brings us to the end of this section. I'll turn it over to Julie now to take us through some hot topics in prospectus filings.
Thank you, Joanna. In this section, we'll go through some hot topics in prospectus reviews, and we'll start with the use of proceeds. A critical part of every prospectus review is considering an issuer's intended use of proceeds or available funds from a non-offering prospectus. A prospectus must contain clear disclosure on how the issuer intends to use the proceeds raised in the offering. This disclosure is important for investors as it provides a clear breakdown of how their investment will be spent. The use of proceeds section of the prospectus requires disclosure of the actual proceeds under the offering. This means net of expenses, leaving the net proceeds that the issuer expects to receive. In the case where there is a minimum and a maximum, the net proceeds under each would also be required. In this section, an issuer must also disclose each principal purpose of the offering with approximate amounts for which the net proceeds will be used. We expect issuers to provide sufficient detail and to be comprehensive in their discussion. For example, generic phrases such as for general corporate purposes or for general and admin would be viewed as insufficient disclosure. We generally expect an itemized description of how the proceeds will be used with an approximate allocation to each item. In addition, an issuer must state the business objectives that the issuer expects to accomplish using the net proceeds of the distribution. This disclosure should include the concrete development milestones that would advance the issuer's business objectives and are expected to be completed within the next 12 months, including a description of each milestone, as well as the expected timing of completion and the financing requirements for each objective or milestone. For example, if the issuer intends to use the proceeds of the offering to complete clinical trials, the issuer should describe that milestone and how it would advance the issuer's business objectives. In this example, if the clinical trials are successful, the issuer will then be in a position to file for FDA or Health Canada approvals. Therefore, we might ask how long the clinical trials will take to complete and the expected total cost. It is important to reconcile the allocation of the proceeds with the expected cost of the milestone. For example, if the issuer has allocated $1 million of the proceeds from the offering to clinical trials, but those trials will cost approximately $1.3 million to complete, an issuer should indicate what other sources of funding are available to the issuer in order to bridge that gap, which may, for example, be cash on hand. Let's look at an example. This slide provides an example of where staff are likely to view the description as insufficient disclosure regarding the use of proceeds. It states that the net proceeds under the offering are $5 million, and the proceeds of the offering will be used towards general corporate purposes, expansion of a production facility, and potential strategic acquisitions. This does not provide an itemized allocation of the proceeds or enough detail to provide investors with information required to gain a fulsome understanding of the use of proceeds. In terms of staff comments regarding use of proceeds, as discussed earlier, it is important to make sure that the response comprehensively addresses comments from staff and provides revised or proposed disclosure to be included in the prospectus. Now let's look at an example of enhanced disclosure. As you can see on this slide, there is much more detail about the use of proceeds with an itemized description and allocation of approximate amounts. In this slide, it states that the net proceeds under the offering are estimated to be $5 million and specifies that this is net of underwriters' fees of $100,000. So we know the $5 million is the actual proceeds from the offering. The $5 million is broken down between a facility expansion and advertising and marketing. As you can see, the facility expansion is explained in enough detail and provides the purpose and expected output of the facility. Further, the amount allocated to advertising and marketing is followed by a discussion of why it is necessary. Moving on to another hot topic in the context of a prospectus review, sufficiency of proceeds and financial condition concerns. The financial condition of an issuer and the sufficiency of proceeds from an offering are critical parts of every prospectus review conducted by staff. In limited circumstances, staff's concerns regarding the financial condition of an issuer or the sufficiency of proceeds may affect our ability to recommend that a receipt be issued for a prospectus, whether the offering is an IPO, new issuance, secondary offering, or non-offering. The Securities Act provides that the Director of Corporate Finance must issue a receipt for a prospectus unless it appears to the Director that it is not in the public interest to do so, or because of one of the specific reasons enumerated in the Act for not issuing a prospectus. As such, a decision maker is prohibited from issuing a receipt for a prospectus if it appears that the proceeds from the prospectus offering, along with the issuer's other resources, will be insufficient to accomplish the purpose of the issuance stated in the prospectus. There may be receipt refusal concerns in any of the following circumstances. It appears that the prospectus inadequately discloses an issuer's financial condition or going concern risk, and the issuer is unable to remedy the inadequate disclosure. Or there is adequate disclosure about the issuer's financial condition, but it appears that the sufficiency of proceeds receipt refusal provision is applicable as outlined on this slide. Or it is not in the public interest to issue a receipt. I will note that this list is not exhaustive. There are other specific receipt refusal grounds set out in subsection 61(2) of the Act. It is also important to note that in reference to the other resources of the issuer, staff will only consider non-contingent resources. For example, if an issuer is in the final stages of securing a loan from a bank but does not yet have a signed agreement, this would not be included in staff's consideration of other resources of the issuer. We would only consider imminent sources of financing where there is a certainty of proceeds, such as a signed loan agreement with funds in transit or proceeds secured from other sources such as a private placement, venture capital, angel investment, and so on. We may also consider receipt of grants and subsidies to cover specific expenses if the issuer can demonstrate it has met all conditions or criteria and received confirmation of award for the grant or subsidy. So, why do we focus on sufficiency of proceeds in our reviews? In reference to CSA Staff Notice 41307, a principal purpose of the sufficiency of proceeds receipt refusal provision is to protect the integrity of the capital markets, which would be harmed if an issuer ceased operations due to insufficient funds shortly after completing a public offering. A prospectus must contain clear disclosure on how the issuer intends to use the proceeds raised in the offering, as well as disclosure of the issuer's financial condition, including any liquidity concerns. This disclosure is important for investors as it provides warnings about specific risks or significant risks that the issuer is facing or may face in the short term, and may help investors avoid or minimize negative consequences when making investment decisions. Relevant information in this context may include disclosure of negative cash flow from operating activities, working capital deficiencies, net losses, or significant going concern risks. We will go over some additional guidance from CSA Staff Notice 41307 in the next few slides. We want issuers to be able to demonstrate that they have sufficient resources to meet their short-term liquidity requirements. The relevant time frame for this will vary depending on the type of each issuer. Some guidelines are included in the table on this slide. As shown, an exploration stage issuer should have sufficient resources to reach completion of the next phase of a project. A development stage issuer should have sufficient resources to achieve their next significant milestone. A research and development issuer should have sufficient resources to achieve progress on the development of a key product. And an issuer with active operations should have sufficient resources to continue operations for the short term, which we generally consider to be 12 months. Based on these guidelines, some of the overarching areas staff cover as part of our prospectus review process include consideration of the following questions. Can the issuer reach the next milestone in their development plan? Does the issuer have enough money to meet working capital and debt requirements in the near term? And does the issuer have enough money for exploration work? And to reiterate, our expectations depend on the stage of operations for any particular issuer. For example, if we have different expectations for a fully operational company that is earning revenues, as opposed to or compared to a research and development stage company, as I pointed out on the previous slide. During our prospectus review process, staff may raise comments in any of the following 5 areas where we have identified concerns about an issuer's sufficiency of proceeds or financial condition. Missing information regarding the offering amount and pricing, use of proceeds disclosure, including, for example, the sufficiency of disclosure as discussed in earlier slides, risk factor disclosure, representations to support the issuer's ability to continue operations, and the structure of the offering. And again, this list of issues is not exhaustive. The types of comments we raise in these circumstances may change, and we will continue to assess and review each prospectus on its own merits. In terms of staff comments regarding sufficiency of proceeds and financial condition, as discussed earlier, it is important to make sure that the response comprehensively addresses comments from staff and provides revised or proposed disclosure to be included in the prospectus. Depending on the response, a possible outcome could be a material disclosure change, or in certain circumstances, a change in the structure of the offering, which I will discuss in the next couple slides. In certain circumstances, revised disclosure to support representations of the issuer's ability to continue operations may be sufficient to satisfy concerns with regard to financial condition and sufficiency of proceeds. When conducting prospectus reviews, we may consider the following to better understand the issuer's financial condition. For some examples related to use of proceeds, In addition to some of the details I discussed earlier, we will ask for revised disclosure to include the issuer's cash and working capital balances as at the most recent month end. We expect the use of proceeds to also address the working capital deficiency, if any. To support staff's review, we may ask the issuer to provide their analysis of anticipated cash requirements over the next 12 months, considering the issuer's rate of cash burn. This may include, for example, general and administrative items, development milestones, debt servicing, and all other expected costs of operating the business or known capital expenditures. For some examples related to risk factors, under subsection 4.31 of Companion Policy 41-101, if an issuer has negative cash flow from operating activities in its most recently completed financial year, for which financial statements have been included in a long-form prospectus, the issuer should prominently disclose that fact in the use of proceeds section of the prospectus. The issuer should also disclose whether, and if so to what extent, the issuer will use proceeds from the distribution to fund any anticipated negative cash flow from operating activities in future periods. An issuer should also disclose negative cash flow from operating activities as a risk factor. Where the offering is being conducted on a best efforts agency basis and we have accepted that a minimum subscription is not required, the issuer is required under item 1.43 and 1.63 of Form 44-101 F1 to include on the face page of the prospectus disclosure that there is no minimum amount of funds that must be raised under the offering. For examples of representations to support ability to continue operations, we will ask for an explanation of any significant differences or lack of expected changes between historical results and performance needed to continue operations for the period which the issuer expects to be able to continue operations. For example, issuers should explain why significant increases to revenues or margins are expected, or why significant cost reductions will occur, and support how these changes are reasonable. In general, we expect the level of detail to be proportionate with the issuer's track record and financial condition. In some cases, where an issuer has an extensive track record of significant cash flow from operations and positive qualitative disclosure about a credit facility, that may be sufficient to address our concerns. On the other hand, we expect greater disclosure if an issuer has limited financial resources and their track record has significant cash used from operations. In either case, staff will assess the reasonability of the issuer's assumptions. I will reiterate that this list is not exhaustive. The types of comments we raise depend on the facts and circumstances of each file, and we will continue to assess and review each prospectus on its own merits. In certain circumstances, disclosure on its own may not be sufficient to satisfy receipt refusal concerns with regard to financial condition and sufficiency of proceeds. For example, when conducting prospectus reviews, we may consider the anticipated proceeds from a prospectus offering to be insufficient if they are raised in any of the following offering structures. First, if an offering is raising funds for a specific purpose but does not address the issuer's short-term liquidity requirements to continue operations or accomplish the purpose of the offering. Next, we may also view the proceeds as being insufficient if they will be raised through a best efforts offering without a minimum subscription, or a minimum subscription that does not appear to be sufficient to satisfy the issuer's short-term liquidity requirements. If funds are raised through this structure, we may ask whether there is a minimum subscription amount. If not, we may have questions about how the stated purpose of the offering and use of proceeds will be achieved absent this minimum subscription. While there is no requirement to have a minimum subscription for an offering, the absence of a minimum subscription could be a significant concern where there are questions about the issuer's financial condition or where a minimum amount of proceeds appears necessary to meet the stated purpose of the offering. Additionally, we may have concerns when an issuer files a base shelf prospectus, which can be drawn down in small increments because when considered separately, the individual drawdowns may not be sufficient to satisfy the issuer's short-term liquidity requirements. In these circumstances, we may have questions regarding the availability of other financial resources to fund the issuer's operations if sufficient financing cannot be raised through the offering. This includes funding of the issuer's business objectives and concrete development milestones in the next 12 months. Ultimately, an issuer may need to change the structure of an offering to address concerns regarding an issuer's financial condition. And with that, I'll now pass it back to Maria.
Thank you. I'd just like to take a minute to thank Luke, Joanna, and Julie for sharing their knowledge and expertise with us today. And before we begin the Q&A portion, I'd like to draw your attention to the appendix in our slide deck, which contains contact information for today's presenters. Please note that while staff are happy to answer questions, this does not replace the advice of independent third-party advisors, as we are, of course, not the attendees' advisors.